Wow, that goes forever. There's
We are
another way.
now complete,
That would have been cool. Good to see
and
you.
we are ready to start the first panel, which focuses on the work of the Eagle. Your program gives a good explanation of the main subject matter, but we're going to be focusing on the regulatory takings doctrine in particular, because that is where a lot of Steve's work focused on and enlightened us. And so we've got three wonderful panelists, but we're going to begin with some opening remarks from Steve.
Well, thank you very much, Lynda. It's just wonderful to have such a distinguished panel here to give you a retrospective and critique of my past work. So I'm going to spend my time talking about some prospective things. My remarks last night at dinner were kind of lighthearted. Today, though, I'm on the more somber side, because I want to talk about regulatory takings doctrine and problems I see coming up. In particular, I think there is going to be a great deal of public demand that land use and property rights be adjusted to take into account things like climate change and the economic agglomeration that leads to extremely successful and high-price areas and areas that are not so thriving. The public is increasingly concerned about this. They want something done. They don't want to pay for it. And so you'll see lots of attempts to place the costs of these changes on narrow groups of people, like selected groups of landowners, landlords, and the like. So these are coming down the pike, I think. Alas, our regulatory takings doctrine is built on somewhat shaky foundations, and that's going to be a challenge. Individual cases having to do with these great adjustments that I see coming down the road are going to be a challenge. So both for theoreticians and for practitioners, regulatory takings is going to be undergoing a lot of stress, I think, in the next few decades. I have a friend who was a staunch libertarian, and he complained to me a few years ago that a nearby landowner was planning to develop his parcel with low-income apartments. My friend added that he and other neighbors were asking local officials to intercede and block this. Somewhat tongue-in-cheek, I told him that I was shocked that someone of his political persuasion would invoke the heavy hand of the state to interfere with private property rights. He looked at me as if I were suddenly bereft of intelligence. And he said, "You don't understand. This is about externalities." Well, yes, it is about externalities, as is every land use case and every development regulation. We're only concerned with the effects of what happens on one parcel as it affects other people. Now, from the left, we've seen heavy demands that, for instance, require developers to heavily subsidize low-income housing units as a condition for new projects and to reinstate strict rent control. The California Supreme Court has referred to this as normal zoning. More towards the center, I've read law review articles elaborating on grand bargains that might be struck by transient self-interested factions in city politics, which would be enforced against democratic subsequent change by their entrenchment as property rights. And who can forget the deregulatory takings cases where owners claimed that deprivation of the monopolies they were granted by the state constituted a taking. From the start, on the right, I've consulted congressional staff members who made it clear that they regard any regulation that has any effect in reducing the value of any property as ipso facto illegitimate. So you have this whole huge array across the political spectrum that we're going to have to be dealing with in the next few decades, as we have in the past. Zoning is pummeled on all sides. The only people who have a good word to say about it are the people, ranging from affluent, progressive suburbanites who like their neighborhoods just the way they are, thank you, through working-class homeowners and urban minorities resisting gentrification. Indeed, local land use controls are most under attack by those demanding state top-down controls over localities. The most definitive guide to regulatory takings law remains Justice Holmes' 1922 admonition in Pennsylvania Code. The general rule, at least, is that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. When I taught land use and property law classes, I've stopped right there and said, any questions about the subject before we go on? And then, of course, there's Penn Central. Now, I and just about every other regulatory takings scholar has bemoaned that Penn Central is, in fact, both incoherent and not very predictive. We all know that Penn Central has three principal tests. Well, or maybe it's actually two. Well, maybe four. That's my assertion. Justice Brennan seems to have appropriated its theme from Professor Frank Michelman, who was the first Brigham-Kanner Prize recipient, I should add. Michelman thought that if someone buys land subject to particular zoning and spends substantial amounts of money constructing a project consisting with that zoning, it ought not to be yanked out from under the landowner. Well, we agree that far. Beyond that, it's rougher going. As I've mentioned, Penn Central has at least three conventional factors: economic impact, investment-backed expectations, and character of the regulation. Some of us, including me, have spent a great deal of time and paper and footnotes poking holes in each one of those tests. The California Supreme Court, in Kavanaugh versus Santa Monica Rent Control Board, has indicated an additional 10 relevant tests and cautioned that the list was not comprehensive. I have to say, all of this reminded me of French Prime Minister Georges Clemenceau, who, upon hearing of President Woodrow Wilson's 14 points to save the world, sniffed, well, God only had 10. Now, if you think things couldn't get worse, you are an optimist. 2 years ago, in Murr versus Wisconsin, Justice Kennedy wrote for the court that determining the relevant parcel for Penn Central analysis did not even presume in favor of honoring discrete, individually deeded parcels, but was itself based on a separate ad hoc test interacting with the Penn Central ad hoc tests. As Chief Justice Roberts noted in dissent, the majority authorized governments to do precisely what the court rejected in Penn Central, to create a litigation-specific definition of property itself, usable only in regulatory takings cases. Recall that Justice Holmes' Pennsylvania Cole decision predated our modern notion of regulatory takings. Maybe the best expression of the goal of regulatory takings is in a 1960s case involving government abrogation of a material supplier's lien, Armstrong versus United States, where the court said the Fifth Amendment's guarantee is designed to bar government from forcing some people alone to bear public burdens which, in all fairness and justice, should be borne by the public as a whole. I know that progressives are terrified of economic substantive due process and Lochner. Conservatives leery of open-ended approaches, demand, as Justice Scalia put it, a law of rules. Nevertheless, regulatory taking seems most likely to become a deepening morass. Maybe a non-timid originalist is needed to point out that the emperor has no clothes. In his dissent in Murr, Justice Clarence Thomas noted that the court, quote, never purported to ground its regulatory takings precedents in the Constitution as they were originally understood. In my view, Thomas added, it would be desirable for us to take a fresh look at how our regulatory takings jurisprudence to see whether it can be grounded in the original meaning of the Takings Clause of the Fifth Amendment or the Privileges or Immunities Clause of the 14th Amendment. Now, I don't expect practitioners to take the lead on this. I don't think courts will immediately be amenable to the change, but I do think it's incumbent on legal scholars to try to find a better framework for analysis of the dilution of property rights through placing unfair burdens on property owners. It's especially important to get our doctrinal ducks in order to deal with the immense pressures I mentioned will be placed on property rights in the next few decades. From a legal perspective, the first thing is we've had a general inchoate kind of presumption that municipalities act in good faith. From a practical perspective, litigation will flow from governmental actions assertedly in response to climate change. And of course, in states where the judiciary seems pro-government especially, much of this litigation after Nick is going to be brought in federal courts. The presumption of good faith was implicitly brought into question by Justice Alito in Coons versus St. John's River Valley River Water Management District. As long as the building permit is more valuable than any just compensation the owner could hope to receive for the right-of-way, Alito said, the owner is likely to accede to the government's demand no matter how unreasonable. Extortionate demands of this sort frustrate the Fifth Amendment's right to compensation, and the unconstitutional conditions doctrine prohibits them. Indeed, Justice Alito might have cited Gerald Caden's classic 1991 article, Zoning for Dollars, which pointed out that zoning is often the result of an explicit bargaining process. Government no longer limits its police power to exclude the harmful, but tries to encompass within its police power so-called fine-tuning to use its leverage to achieve what officials regard as optimal development, optimal collection of fees, or some combination never quite specified. The justices seem to regard the 1999 Del Monte Dunes case as exemplifying this notion of bad faith. And in the context of Coons itself, a landowner was told he can obtain a development permit by, among other things, contributing money for a project on land owned by the regulating agency itself. So, in June, in Nick versus Township of Scott, the Supreme Court repudiated the state litigation prong of its Williamson County doctrine and held that a taking occurs the moment that a compensable state action occurs. But the other prong of Williamson County, the final determination prong, remains on the books. It's awfully hard to get someone to give you a final answer when their livelihood and successfully funding off your project often depends on their not doing that. In Palazzolo versus Rhode Island in 2001, the court made it clear that it would focus on the practicalities of when the final determination took place, still a lot loosey-goosey. The upshot of this all is that individual bargains between developers and regulators may be examined in a more critical light. In a post-Kuntz article, I likened informal bargaining between local land use officials and developers' attorneys to police station interrogation, where the suspect's legal rights are sometimes, shall I put it, not scrupulously observed. And that process is left for the courtroom, by which time it's usually too late. So, how does one deal with this question of bad faith and extortionate conduct? I think this is going to lead to less flexibility and to more general and more objective sets of tests being established. Climate change is going to generate immense takings problems. Many believe that the mitigation of change is crucial for present and future generations. Others think this is a handy, ostensible justification for the densification of development that planners and city elites have long pined for. Collective action problems are immense, since almost all of the benefits of greenhouse gas mitigation are going to inure to other landowners, other communities, other nations, and other generations. The failed recent California attempt to compel suburbs to accept dense housing near transit stations is one example of popular resistance, which we're going to see a tremendous amount of. Adaptation to climate change on the individual parcel level is much more palatable, since that benefits the landowner, him or herself. But it also makes individuals who have made those expenditures far less amenable to spending money on more community-based solutions to the same kind of problem. Managed retreat is going to be the most formidable and difficult of all. There was a triage plan developed by the Urban Land Institute for New Orleans in the wake of Hurricane Katrina. And that would have resulted in large areas of the city being condemned. These areas were below sea level, typically occupied by lower income people and often minority group members. In theory, this kind of condemnation could have been done very cheaply, since the post-Katrina value of that land was pretty close to zero. But even when there was talk of paying pre-Katrina condemnation awards, politically it went nowhere. The city just could not accept that kind of distinction between the haves and have-nots. In Berman versus Parker, the Supreme Court upheld the condemnation of a sound building in a blighted neighborhood on what I think is the specious theory that once something is in the authority of Congress to do, the right to realize it through the exercise of eminent domain is clear. The court says, for the power of eminent domain is merely a means to an end. Well, I think that the Just Compensation Clause and the public use requirement are a little more than merely things that the government has to check off. I'm sure other panelists will pick up on that. The point, though, is that in the Kelo case, although the government won, I think that consolidated popular resistance to the notion that there was carte blanche for the government to take private property for generalized purposes, and certainly for a coordinated retreat, moving an entire community from one area to another, I think would be something the current court also would find disagreeable. A final legal problem I want to mention is affordable housing. This has come to the fore largely because of agglomeration. Agglomeration refers to the fact that once you start getting a critical mass of workers and businesses of a certain industry in the same locality, it feeds upon itself. More workers come to work in that industry, more businesses settle there. Silicon Valley is a perfect illustration of that kind of situation. Some areas of the country are becoming extraordinarily productive. Others largely are decaying in place. And there are endless political ramifications of that, many of which we've already started to see. Affordable housing often is given as a panacea in this situation. I've argued in a recent law review article that affordable housing is simply a metaphor. Everyone thinks it's a great and no one agrees on what it means. We know that all housing is affordable in the sense that developers won't build it unless someone will be able to buy it. Beyond that, it's a problem of who we're talking about, who is to be benefited, how much we should give precedence to in the name of growth, how much we should give precedence to in the name of keeping existing populations in place. These two are going to be very difficult burdens, and we see them growing. Inclusionary zoning and similar kinds of requirements, forcing isolated existing landowners to bear the burden is just one illustration of the problem. Same thing with rent control. Almost all economists, 98% in a recent famous survey, agree rent control results in less housing, more expensive housing. It's bad all the way around, except for existing residents who are crying out for results. There's going to be a lot of regulatory regulation on that. The Penn Central Doctrine provides no clear doctrinal framework to deal with these questions, and in terms of practical realities, the contest for primacy between private property as denoting individual autonomy and governance property as denoting the advancement of human flourishing will be very much in the courts as well as in the news. Thank you.
Okay, it's a great pleasure to speak on this panel honoring Steve Eagle for his work. I have long thought that Steve is one of the very few academics that have advanced a alternative theory of regulatory takings to the one that the Supreme Court has willy-nilly endorsed. Unfortunately, Steve's theory is sort of buried in some of the pages of his massive treatise on takings and in a few law review articles which have gotten insufficient attention. My job here, I guess, is to sort of highlight what I think the Eagle theory of regulatory takings is and why it warrants much more serious consideration than has been given up to this point in time. The great virtues of the Eagle theory are that it would put regulatory takings on a much sounder and secure foundation than the quicksand on which the Supreme Court's theory currently stands. Its weakness, which Steve has openly acknowledged, is that it would result in a more compact doctrine than the one arguably we have now, and hence, if we're interested in protecting property owners from various forms of aggressive government action, it would be necessary to supplement regulatory takings with something like substantive due process, which of course is a heavy lift given the assaults on that doctrine that have come from people otherwise friendly towards property rights like Justice Scalia and Justice Thomas. So to highlight the difference between the court's theory of regulatory takings and what I will call the Eagle theory, I think it's the most economical way is to focus on the language of the Takings Clause. The Takings Clause says, "Nor shall private property be taken for public use without just compensation." Now, the Supreme Court, and I don't think they have given this any thought, but I think the Supreme Court's approach to regulatory takings has been to show relative indifference to the words private property and paid no attention to the words just compensation. The court's never gotten around to figuring out how you'd measure just compensation in a regulatory takings case, because it's almost never found a regulatory taking. But the courts put all the emphasis on the word taken. So the court's jurisprudence, I think, can be seen as a very elaborate attempt to give a creative and not particularly conventional understanding of the word taken, such that it refers to any type of government action which unduly interferes with the reasonable expectations of property owners. Steve's theory, in contrast, as I understand it, gives a fairly straightforward, ordinary meaning to the word take or taken, and presumably a fairly ordinary understanding of the words just compensation, but puts all the emphasis on the words private property. And I think this is a much more promising basis for articulating a theory of regulatory takings that would stand up against some of the criticisms that have been leveled against that doctrine over time. The first thing I think to note would be which approach is more consistent with the original meaning of the Constitution, or what people at the time of the framing might have thought the Constitution was saying. The court's approach, I think, and Justice Scalia actually conceded this in his Lucas opinion, can't really be traced to any type of original understanding. He, as he put it, it was based on the historic compact which has emerged over time. Basically, the regulatory takings doctrine of the court is a quintessential example of common law constitutionalism. The court has sort of stitched together various notions derived from contracts clause and substantive due process jurisprudence about protecting expectations, and various notions which emerged in the 19th century from the Commerce Clause and the Contracts Clause about the police power, and putting this all together has cooked up this regulatory takings doctrine. The Eagle theory, I think, well, first of all, we don't know much about what the framers thought they were doing when they adopted the Takings Clause. There was a couple states had takings clauses. The Northwest Territory Ordinance had a takings clause. But I think you could say two things that were highly, we can say with some security, that people understood about government's interaction with property in the wake of the adoption of the Takings Clause. One, I think no one has ever contested that the Takings Clause applies to explicit takings of property by the government in return for public uses, whatever that means, in return for just compensation. I think there's never been any question that the language, to the extent that it applies to some level of government, and that took a long time to work out with the adoption of the 14th Amendment and so forth, but that the language at least covers explicit actions in eminent domain. So eminent domain requires just compensation. At the same time, public nuisance law had been around since the 15th century, regulated property in many respects, and it was a common understanding that if you were acting to prohibit a public nuisance, no compensation was required. So these two propositions were secure at the time of the founding. I don't know of any document in which any framers sort of had an aha moment and said, well, gee, there's going to be sort of a boundary line problem here as to when we're in the eminent domain arena and when we're in the public nuisance arena. But I think if they had thought about it, they would have readily conceded that you would need some kind of understanding that the courts would prevent the government from labeling anything and everything a public nuisance in order to evade the compensation requirement that the Takings Clause, newly enacted in 1791, imposed. And so I think the Eagle theory basically generates the need for this type of doctrine. The idea is that a regulation should be deemed a taking that requires compensation when any sort of interest that could be called private property that ordinarily would have to be acquired by purchase or by eminent domain has been acquired through government regulation. So the Eagle theory, I think, can be derived without too much calisthenics from plausible understandings at the time of the founding. Another aspect of the Eagle theory that I think is appealing is that I think it would garner a high degree of consent from various contemporary actors, lawyers, judges in particular, who deal with these sorts of issues. It's a rather modest theory. It simply says that if we're going to have this understanding that when the government explicitly takes property, it has to pay just compensation. It's necessary to have some kind of anti-evasion principle. The Supreme Court's regulatory takings doctrine, in contrast, has been a matter of controversy since Penn Central, if not before, and does not achieve any kind of general assent from the legal community the way I think the Eagle theory would. A third point to make, and Steve kind of anticipated all this in his opening remarks, is, which approach would be more predictable, would generate lower litigation costs, and so on and so forth. Well, the Supreme Court's theory is a clear loser on these grounds. Steve, I think, has given you enough data to make that conclusion. It's got this multifactorial Penn Central test, and we don't know how many factors there are. And now we've got the Murr test, which compounds. It's like Penn Central squared, as somebody wrote. And there are these exceptions for, appropriations or seizures, Loretto and Horn, and then there are the Lucas exception and so forth. But when you put the whole thing together, it's a monumentally complex doctrine that generates large litigation costs. I don't think that Nick is going to solve this. I think Nick knocks the underpinnings out from under Williamson County, but there's going to be a whole bunch of controversies about when you can go to federal court and when you have to stay in state court under principles of equity and so forth, whether there's an adequate remedy at law in form of just compensation, et cetera. So I think the court's approach is very unpredictable. Now, what about the Eagle theory? Now, the Eagle theory is interesting, I think, because it basically puts the focus on private property. And so the inquiry would be, has the government, by regulation, done something which takes, in the ordinary meaning of the sense, private property? Steve has suggested, and I think quite insightfully, that we should define private property, in this context at least, as what is sort of commercially exchanged in the local market. I have written a little bit about this, not quite in the same vein as Steve, suggesting that property for these purposes should be defined as assets to which people have exclusion rights that are exchanged on a standalone basis. I think it's basically the same thing that Steve was trying to get at. One interesting implication of Steve's approach is that the regulatory takings doctrine would now become largely a question of fact rather than doctrinal manipulation. So the question would not be whether, under some kind of complicated three-part test with exceptions and exceptions to the exceptions, blah, 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 a taking in some kind of metaphysical sense has occurred. The question would be whether in the local market where the government regulation applies, the interest the government has acquired, the bundle of rights, if you will, the government acquires, conform to a set of rights which are exchanged in the local commercial market or on a standalone basis. As Steve puts it, and this sort of leaves a lot of room for debate in between, if the government regulation sort of ties up 50 acres of land that can't be used for any other purpose than what the government wants to use it for, that's pretty clearly a taking of private property. If the government says you can't use the 50 acres for landscape painting, well, that's probably not a taking. Because we don't exchange the rights to paint 50 acres for a landscape painting in the commercial marketplace. But but the question would become one for either the court to take judicial notice of, as a matter of fact, or for expert witnesses to testify about. So I think, interestingly, some things that are now deemed to be not regulatory takings, like wetlands regulations and historic preservation ordinances, probably would be a taking today under the Eagle test, because today we have exchangeable conservation easements, which accomplish these same things. Sometimes they're donated, sometimes they're actually purchased. And they're purchased on a standalone basis. They're not tied up with any other acquisition of property rights. So in that sense, the Eagle theory would actually expand the protection afforded by regulatory takings. On the other hand, the Eagle theory would put out of bounds any sort of challenge to some of the things he mentioned, with the disparaging overtones, rent controls, affordable housing mandates, in the regulatory context, rate orders that put companies out of business and so forth. These things are not exchanged on a standalone basis. They're in a commercial marketplace, and hence would not be subject to regulatory takings. So I think Steve's theory has some very powerful strengths. You can justify it in terms of plausible original understandings. It would obtain high degrees of consensus among current legal actors. It would be much more predictable and administrable, I think, than the current doctrine is. It has a drawback, however, which I've already alluded to, which is it's because it's compact and because it's powerful, it does not extend to every kind of interference with property rights that property owners or their advocates might think requires some kind of government intervention. So as Steve very forthrightly acknowledges, we'd have to have something like substantive due process to backstop the regulatory takings doctrine. The problem with that, of course, is that in circles that are somewhat generally sympathetic to property rights, substantive due process is not well received. There's been a lot of lambasting of it by people like Scalia, Thomas, Judge Easterbrook, etc. I think the better strategy is to sort of give up on doing battle with substantive due process. It's not going to go away. This court's not going to repudiate the privacy rights doctrine and so forth. In fact, there are pockets where substantive due process has been endorsed by the court fairly recently, like in the punitive damage cases, which protect property. And hopefully there'd be some movement in the direction to reinforce substantive due process if, in fact, the court finally woke up and saw that the Eagle theory was a much better basis for regulatory takings law than the mishmash it's given us. Thanks, Steve.
We've already had a very interesting set of ideas, but we're going to go through the entire panel before we open it up to comments among the panelists and Steve and to the audience. David?
Thank you very much, and it's a great pleasure to be here again. I certainly enjoy not only the festivities connected with this program, but the opportunity to chat with colleagues and to exchange ideas about land takings and things of this sort. I think, speaking for myself and maybe for my colleagues up here, we committed a cardinal error, if you will, that any neophyte litigator would not fall into, and that is not getting Steve's comments in advance so that we know what he's going to say. I'd like to have taken his deposition at this point. I think that would have probably guided my remarks. It's a great temptation to take this 50 pages that I plan to just read from, sorry, and toss it on the floor and start all over again, but I won't do that because it would be very scattered, and we can take that up later. I'll leave that to Jim. I come to you, this is called kicking the can down the road. I come to you from a relatively small state, an island state. No, it is not, as some inset maps located just off the coast of California. There is no ferry. I have been asked that before. And so we're a little further away. We did have an attorney general at one time that seemed not to quite know where Hawaii was, and even that it was a state. But that's fortunately past us for all kinds of reasons. We do have one interesting point, which does, I think, prejudice me to somewhat with respect to some of the things that Steve said, and indeed probably what many of you would say, and that is that we come from a jurisdiction that has no cities, no villages, no towns. We have 4 counties, 4 municipal corporations, that's it, the only state in the union. So when, as I do, teach state and local government law in a federal system, you haven't got a lot to say with respect to intergovernmental relationships at the local level because we don't have any. We just have the 4 counties. Trust me, if you'd like to talk about it later, it does not make things easier, and it does make annexation agreements, of course, irrelevant. Stephen Eagle's contributions to the law of regulatory takings are legion. He has done absolutely fabulous work. His treatise is the benchmark that to which we all look for commentary. And it's very straightforward. His witty commentary on the law, sometimes quite scathing, come from his articles. So a number of years ago, I rashly made a few predictions on the way regulatory taking was going to go. As another colleague from another university indicated, if you want to make predictions with a crystal ball, you got to be used to or risk eating ground glass. And so I'm not sure that many of the predictions have come true, but I'm first going to run quickly through what the predictions were, and then attempt from the vast body of work that represents what Stephen Eagle has done over the past 40-some years in teaching and commenting on law, had to say about them, and then conclude very quickly with a couple of remarks that come largely from what Stephen has said in the last hour or so. First, the predictions. Land development conditions would continue to come under even more scrutiny for nexus and proportionality. Number two, we'll continue to be confused by the difference between legislative and administrative quasi-judicial exactions. Number three, there will be more use of consensual tools like development agreements. Number four, the Supreme Court will continue to re-examine its decisions with respect to kilo and physical takings. Number five, the courts will continue to wrestle with exceptions to per se government takings, and the public trust doctrine will be an issue. Number six, if a government is passing a regulation that is essentially abating a nuisance or has got to do with the background principles of common law, property, custom, and the public trust, that will be a safe haven for government when it enacts total taking regulation. Number seven, the court will cut back on the application of the ripeness rule. Number eight, partial takings will be decided more on the merits, but with mixed results. And finally, the court needs to and will resolve the so-called relevant parcel or denominator issue, both with respect to partial and total regulatory taking. We know how that got messed up. So, prediction number one, with respect to land development conditions. Stephen has written a fair amount on this issue, and I think it's worth noting what he has to say. He wrote several articles, including Kuntz and the Mansion and the Gatehouse, and a couple of others, and he predicts that there may be increased value for cooperative developers because out-of-area competitors may be unwelcomed by local officials who fear that exactions imposed on projects will give rise to litigation. He further suggested that the fact that local government interests often are overrepresented on zoning boards seems consistent with local favoritism. As Stephen acknowledged, the fact that professional developers treat the possibility of unjustified exactions as part of the cost of doing business does not mean that extortion exactions are victimless wrongs. The effect of such voluntary exactions is in large part passed on to housing purchasers and their tenants, and notably there are many cases in the land use context involving extortionate behavior by governmental agents that never get exposed because a large number of these cases never reach the courts. The partial point of all of this, Stephen, is that you're going to want a lot of rebuttal time, which I'm not going to give you. And time doesn't do it, which is nice under the circumstances. And also in Property Rights After Horn, Stephen explained how Horn reinforced the theme of Nolan and Kuntz and provides more security with respect to its application of categorical takings treatments to appropriations of personal property. Prediction number two, the courts will continue to wrestle with the difference, if any, between legislative and administrative quasi-judicial exactions in the application of Nolan, Dolan, and Kuntz. It's a very difficult area, and of course many courts have decided that there should be such a difference, more that will grant legislative determinations a greater degree of I suppose one could say strength and deference as opposed to other kinds of exactions. And in that area, once again, Stephen indicated in his land use regulations and good intentions, in pertinent part, he examines the pervasiveness of exactions in planning. He says that the argument to immunize legislative exactions from heightened scrutiny is necessarily imbued with a tacit criticism of administrative actions, with which I certainly agree. This might produce spillover effects on the many eminent domain and regulatory taking situations that involve administrative acts unrelated to exactions. In addition, it might result in a pronounced shift in land use policy towards broad, unbending legislative measures to avoid heightened scrutiny, which would preclude finer-grained administrative regulations that would take into account the personal, political, and economic identities of these patterns or groups affected by the conflicts. He also suggested under prediction number 3, there will be more consensual tools like development agreements to resolve exaction issues. These agreements take exaction issues out of the Nolan-Dolan context altogether. Stephen discusses in his monumental treatise that Virginia proffers will be increasingly used and recognized, and local government will try to impose concessions under those circumstances which might not survive. Nolan-Dolan Coutts analyzes by providing statistics that local governments can vest development rights conferred in exchange for concessions, but he notes that it requires proportionality with respect to these concessions and what government shall restrict or grant. I'm not so sure about that. I think what you get in the context of consensual situations, however characterized, development agreements, annexation agreements, private partnerships, whatever, are clearly going to be a way out of the exactions jurisprudence that's represented by Kuntz, by Dolan, and by Nolan. And I suggest that most commentators have so far agreed that this kind of development by agreement is likely to increase by a good amount. Number 4, until the United States Supreme Court re-examines its 5-4 decision in Kelo, government and especially redevelopment agencies will continue to take private property on the flimsiest of public premises. I think that that's probably true, and in that regard, I think that Stephen and I are in agreement. He wrote an article called Public Use in the Dirgestic Tradition. If I screwed up that name, maybe I have. Private and public benefit in an era of agglomeration. And he indicates he's focusing on the Supreme Court's and New York Court of Appeals approach to the requirement that takings be for public use. He argues that the Supreme Court's public use doctrine is conceptually incomplete, and in particular, as he indicated in his opening remarks, he discusses the New York Court of Appeals in Goldstein and Cower, which display uncritical support for the development of economic agglomeration. Steve has an undergraduate degree in economics, in business, in case that isn't clear from what he has to say. He is a law and economics person. I should say that I am one of the few endangered species that are not. That's because I like 3 and 3 to equal 7 or 5 every once in a while, and that's why I became a lawyer. That level of exactitude I'm not capable of doing easily. In the Supreme Court Economic Review Symposium on Post-Kelo Reform, Eagle discussed how Kelo has intensified trends toward increased government land use regulations to spur economic development towards partnering with private developers. And he discusses 2 problematic and related developments in the relationship between the state and owners of land. The first is government's increased intervention in land use, with its regulatory focus shifting from sanctioning nuisance to sanctioning owners who do not use their land to further government economic objectives. And the second is increased governmental alliances with private developers. I think both are true, and I think that's certainly going to be true, especially after Kelo, which virtually created another area or sub-area of public use and joining public use and public purpose for the first time officially. And in that area, Stephen and I are, I think, in absolute agreement. The use of redevelopment agencies. Yes, I agree that Kelo unified a movement against the kind of thing that the Supreme Court decided in Kelo. Justice Stevens, the late Justice Stevens, who comes from my home state of Illinois, my previous home state of Illinois. I'm going to get shot by my folks from Hawaii here. My home state is Hawaii now, but I did grow up in 63rd and Kedzie in Chicago, so that's still sort of a home. I think it's clear that as Stevens said, let me back up. As Stevens said, he regrets that decision apparently more than any other in his career. He says that in his autobiography. He didn't expect the storm of protest that came up that arose after the decision was rendered. The decision, in my view, was flat wrong, and it was again a 5-4 decision. Most unfortunate, but I don't think it has really affected the courts very much. And I think that the trend is still towards favoring the kinds of economic emphasis on, if it's for an economic purpose, then it's okay, and that's a sufficient public use or public purpose, and the use of eminent domain will stand. Again, I think that's unfortunate, but I don't see much of a trend the other way yet. In another couple of predictions that sort of go together, the courts will continue to wrestle with the exceptions to per se government takings, and the public use doctrine will be an issue. And government is passing regulation that essentially abating nuisance. That's a background principle also of common law property, and public trust seems to be involved there. And this gives government a safe haven, even if they take all economically beneficial use with respect to takings. This also raises the issue, of course, that was decided by the Nick case having to do with ripeness. And so let me be a tad bit extemporaneous and depart from my paper, which for me is always a risk, so please bear with me. The Nick case opens the federal courts, as they've never been opened before, to regulatory takings, especially from local government, and arguably, despite some notions of state immunity, through state regulation of land use as well. And I'm from a state like California and the Northwest states where there's a lot of regulation of land use at the state level. Indeed, we have arguably statewide zoning in Hawaii. It divides all the land in the state into 4 districts. 90% are in non-development districts, and only 5% of the land is in clearly development districts. So there is a concern about what state courts have been doing with respect to regulatory takings in the very development active states. I'm pretty sure still Florida, I know in California, I know in Oregon, I know in Hawaii, and I know in Washington that the government gets a much more friendly reception in state courts than they do or should get, at least from the time that federal courts were open before the Hamilton Bank case and ripeness, than they do in federal courts. And so I think a clear example, which I think proves my point, is a relatively recent 2017 decision of the Hawaii Supreme Court, which looks like it's a Lucas case, but gets decided in total contrary to the way the Lucas case and the decision came down. A county in Hawaii designated 9 coastal lots as park, and then proceeded in its plan, and the plan in Hawaii had the force of law. This is the famous Leone case. And then the state the county went about acquiring 3 of those lots, and then ran out of money, which is fairly typical on expensive beachfront land for park. One of the owners of the remaining lots sought a building permit to construct a single-family home, since the land was zoned for single-family residence use. And the county said, no, I'm sorry, but this is park land. We've designated it as park land. We won't give you a permit. So the case eventually wound up in the Hawaii Supreme Court on a Lucas total taking challenge, no economically beneficial use. As in Lucas, the issue was whether the landowner could build a single-family residence on the property. And the county had clearly said no, and suggested such useful activities as renting kayaks, which might be a use of the property. The case went to a jury. There were 2 sets of experts, and the county's expert said, well, you know, land always has investment value, and this land has investment value. And since it has investment value, there has been no taking. The jury bought that argument. The judge agreed, and the Hawaii Supreme Court agreed as well. Now, if land can be designated as park, and no economically beneficial use, let's leave value aside. Justice Stevens was big on value in most of his checks. He tried to convert the Lucas test to no value rather than no economically beneficial use. then there's virtually no limit to what state courts can do when faced with a regulatory taking challenge, which is why, in my view, and I think in the view of a lot of folks, the federal courts need to reopen themselves, and they have been reopened now, so that these challenges can be brought in federal court rather than in state court, and a fair, if not a different result takes place. I can't believe the federal courts in Hawaii, looking at Lucas, would have said that this wasn't a taking, since there was no allegation of an exception. Now, after that extended frolic and detour, which took a good bit of my allotted time here, the relevant parcel, unity of ownership as parcel as a whole. Stephen has said that the parcel, in the parcel and then some, unity of ownership and the parcel as a whole. He discusses the parcel as a whole doctrine and ultimately asserts that the proper foundation for it is the common law doctrine of appropriation to use. He then analyzes unity of ownership theory as it is related to coordinated development by separate owners of contiguous parcels and criticizes the unity of ownership theory because it evades rules for determination of ownerships that have been clearly established under real property, partnership, and business law. I think, to the extent that I understand all that Stephen's actually right. Murr was an unmitigated disaster. It is about the only U.S. Supreme Court case in recent history in which all the parties were dissatisfied with the result. And I think that that's probably appropriate. Justice Kennedy, in my view, is having a great deal of fun on the court, taking a contrarian standard stance time after time so that he became the deciding vote. And inevitably, if you look at his decisions, it gives you no clear line. All of his decisions on this area that he got to write sort of end up with one short phrase: it depends. And all the practitioners in the audience know that that is not a great thing to say to your client. Well, here's my problem. Do I have a cause of action? It depends. That's not what they want to hear from you. They want to have an answer. And so this to me is a relatively important aspect of what Stephen has done. Got a couple more issues here, but I'm hoping that the series will accept my paper in some fashion or other, and you can read all 50 pages online. If you've got nothing else to do and you're trying to get to sleep at night, it would be great. You can read this and go through it. Let me just conclude by saying a couple of things, and that is, aside from the fact that I think Nick reopens the door to federal courts. I think that Kuntz and land development conditions are going to be, since it says that all conditions, money, exactions of property, whatever, are all going to be subject to nexus of proportionality, that means that increasingly it's going to be a negotiation. For the last 30 or 40 years until Kuntz, for sure, it really didn't make much sense for local government to engage in much negotiation because they had the whip hand. They were going to win eventually, even with Nolan, Dolan, and Kuntz. Take a lot of time and throw up a lot of issues claiming that Nolan and Dolan didn't apply to monetary exactions. Kuntz put a stake through that particular theory. So I think we're going to see a lot of development agreements, a lot of public-private partnership agreements that are going to have the force of law. And my guess is that fewer and fewer cases are going to go to court on the whole, but those that do are going to wind up in federal court, and that I think government's going to have an increasing problem with that. Thanks very much.
I will stand so I can look at my computer and I don't have to put it on my lap as I talk to you. While it is coming up, I just wanted to mention that a recent story out of California that sort of is emblematic of where we are in the state of California. So wherever you are, not California, you think things are bad, just wait. The city of Encinitas, which is just north of San Diego, and it's right where the ferry to Hawaii takes off, decided to let homeless people camp on city property. Now they are subject to fines and an enforcement action from the California Coastal Commission for allowing the homeless to camp on their property without a permit. It's great to be in California.
I want to make sure you're on.
I'm on. Oh, Mike.
Well, you don't need to show anything up here.
No, I don't. No, I just,
I thought you were waiting for it.
no, these are my notes.
Okay,
And
your
they-
notes there.
and
Okay,
my
great.
notes are-
Sorry, Jim.
No problem. So
May I have about 5 minutes?
I represent the practitioner side of this panel. We have some great academics. And I have to admit that I really enjoy being on Stephen Eagle's panel, because I've been here and I've been on panels, and there have been some academics on panels where I look at them and say, you know, everything you're saying is theoretically right, but I'm never going to go in court with your ideas, because I like to win in court, and it's not going to happen. Now, with Stephen Eagle, there are actually practical ideas that you can use. And when you look at his treatise, we talk about this he begins his treatise with this sentence: an uneasy tension exists between the right of individual citizens to be secure in their property and the power of government to regulate these property rights. And this tension isn't new at all. Indeed, the underlying subject matter of the treatise has been around for a long time. Government has been with us almost as long as private property. Unless you define property as coming from government, then government has been around longer than property. So that's the one debate we can have. But one thing I tell our new attorneys, if you want to know about regulatory takings, we don't have a horn book on it. We have Professor Eagle's treatise, and they look at it and they see it's this tall, and their eyes go like this, and say, aren't there just some cases I can read? And I say, absolutely. Go to Star Trek land, take the universe, and take the opposite universe. Remember, Captain Kirk became evil in the parallel universe. So we have these series of cases. We have, go ahead and read Penn Central from our universe, and then read Keystone Bituminous from that other alternative universe. Read Mugler from the other universe, and then read Lucas from our universe, talks about nuisance and takings. How about Penn Central? Here we have another universe altogether where you have Penn Central squared, cubed, or whatever with Murr. We have first English on the good universe, and then Tahoe Sierra in the bad universe, and then Nolan, Dolan, and Kuntz, and then you can read any inclusionary zoning case from the Ninth Circuit to get the other universe. There's Palazzolo versus Guggenheim, and you can read all these cases, and you will know exactly what you need to know to lose your regulatory takings case. So then I say, after you read that, go look at Professor Eagle's treatise, because it is a very, very good introduction, not only to the nuts and bolts of regulatory taking, but the theory behind it. When you open up a treatise that says regulatory takings, you don't necessarily expect that you're going to get a very comprehensible and understandable description of public choice theory, of economic theories that is in there. We have what Professor Eagle has done is take a given substance and form to a chaotic series of arguments and counter-arguments that make up regulatory takings. So at least you can see easily what these arguments and counter-arguments are, and then you can use them in court, no matter which side you're going to be bringing your argument. And so with his work, I think we're better able to put flesh on the various permutations of the takings doctrine, and we're able to discern what we're talking about when we're focusing on regulatory takings. So it's a very valuable background. And he takes this deep dive into property rights, the Lockean theory of property. Where does property come from? Does it come from us? Does it come from nature? Does it come from government? So that kind of discussion is in this book. And I think it's critically important if you're going to dedicate a significant period of your time to defending property rights or defending government, to understand the underlying theories of it. And that's why Professor Eagle's treatise is so good for doing that. Now, his work provides the background necessary to understand what's at stake with the doctrine of regulatory takings and the debate over the legitimacy of the doctrine that actually is out there and what that debate entails. So I'd like to say his work provides context to the confusion that surrounds a lot of the doctrines of regulatory takings. As one quick example, before I go into a more extended one, on the doctrine of unconstitutional conditions, where we have Nolan and Dolan and Kuntz and all the permutations of that. When you read Professor Eagle's article, where he talks about the gatehouse of the police that he just described in the mansion, it's an idea of understand. It helps one understand what you are actually dealing with when you are negotiating or when you're dealing with the imposition of conditions. So the application of the doctrine of unconstitutional conditions will work only if it's explainable, understandable, and practical. And the articles that Steve Eagle does in the treatise, I think, puts enough flesh on this doctrine that it is understandable and comprehensible and therefore usable. Now, when you're talking about the doctrine of regulatory takings, we've heard some remarks about, well, is it legitimate? Does it comport with the original meaning of the Constitution? So let me focus on that just a bit. Because as we heard from the quote from Justice Thomas that was cited earlier, he mentioned that the courts never purported to ground the precedents of the Constitution as it originally was understood. It would be desirable, he says, to take a fresh look at our regulatory takings jurisprudence to see whether it can be grounded in the original public meaning of the Takings Clause of the Fifth Amendment or the Privileges or Immunities Clause of the 14th Amendment. So I've looked at a lot of the scholarship, and there's a lot of scholarship out there, and I'm just going to summarize some of that briefly. But I think the doctrine of regulatory takings is of long-standing pedigree. It's not necessarily a new and novel construct that just came out of the mind of Justice Holmes in 1922, and it has meaning that's derived both from the common law and the original meaning of the Constitution. But of course, my view is not universally accepted. There has been a lot of people that have questioned this. The tension that Professor Eagle identified and the power of government to regulate property rights. Those people who want government to have more power, not so coincidentally, are the same general people that say that the doctrine of regulatory takings is untethered to the Constitution. And those, like myself, who advocate more for property rights, we're inclined to find that the doctrine of regulatory takings is based in constitutional history. But people have not agreed with that. Justice Blackmun, for example, in Lucas' case, he said, quote, long ago it was recognized that all property in this country is held under the implied obligation that the owner's use of it shall not be injurious to the community. True enough. And the Takings Clause did not transform that principle to one that requires compensation whenever the state asserts the power to enforce it. Well, that's kind of, I think, a exaggerated gloss on what people are saying the doctrine of regulatory takings is, but that sort of hostility does exist, and it informs people's understanding of the constitutional nature of the doctrine. He continued, it's not clear from the court's opinion, Lucas, where our doctrine of regulatory takings comes from, but it does not appear to be history, he says. In short, I find no clear and accepted historical compact or understanding of our citizens justifying the court's new takings doctrine. What makes the court's analysis unworkable is its attempt to package the law of two incompatible eras and peddle it as historical fact. You love it when the Supreme Court justices get testy. Now, Justice Scalia has kind of bought some of this when he responded by saying prior to Justice Holmes' exposition in Pennsylvania Coal, it was generally thought that the Takings Clause reached only direct appropriation of property, or the functional equivalent of practical ouster of one's possession. And he continues that Justice Blackmun is correct that the early constitutional theorists did not believe the Takings Clause embraced regulations of property at all. And then he continues, since the text of the clause can be read to encompass regulatory as well as physical deprivations, we have to take that as it comes. Now, in Tahoe Sierra, Justice Stevens piled on, said that our jurisprudence involving condemnations and physical invasions is as old as the Republic, and for most part involved a straightforward application of per se rules. Our regulatory takings jurisprudence, in contrast, is of more recent vintage. So, a number of the justices, even those inclined to rule for property owners in regulatory taking cases, do question the legitimacy and the origins of the doctrine. One of the strongest and most strident articles written on the side that the Takings Clause does not encompass regulatory takings is Professor Michael Treater. And he argued, while evidence of the original intent is limited, it clearly indicates that the Takings Clause was intended to apply only to physical takings, and the early case law interpreted it and its state counterparts as not extending to government regulations. And he continues, many of the framers believe that government could, and in the interest of society often should, limit individuals' free use of property, balancing societal needs against individual property rights was left in large part to the political process. And Treanor then posits that maybe Madison's strong concerns about property rights was really motivated by his concerns that slave owners must be compensated if slavery were otherwise abolished. Now, that's kind of a dig on Madison's theory on property. I think it's broader than that. Be that as it may, there's one other scholar I mentioned who's written extensively about this, Professor John Hart, in an article, Colonial Land Use and Significance for Modern Takings Doctrine, said that regulation, he talked about regulations of the time of the colonial era, and there were all sorts of land use regulations that he talks about. Landowners had to continually occupy and improve their land, fence their land, maintain an adequate price for, it pays for mining land, utilize potential mill sites for milling, draining swamps, removal of barberry bushes, et cetera, et cetera, et cetera. And so his thesis is that landowners had to affirmatively use their property, and they were subject to all kinds of regulatory constraints. And he continues, history flatly contradicts a supposed tradition of minimal land use regulation in early America. And then he continues, the evidence concerning the framers' experience with land use regulation suggests that the Takings Clause means what it says about land use regulation, nothing. Now, it goes on in that regard. But there are others that have looked at the same thing and had come to opposite conclusions. Most primarily is a then law professor of Kobach, Chris Kobach, who has gone on to other more notorious political things. He had an article in 1996 called The Origins of Regulatory Takings, Setting the Record Straight. And he begins, I challenge the notion that the recognition of regulatory takings first occurred in Maine in 1922, arguing that this jurisprudential step took place not in the 1920s, but in the 1810s. State courts interpreting the takings clauses of their constitutions and refining state common law delineated the early contours of eminent domain doctrine in America. And many of these early expressions of takings law embraced what we might now describe as regulatory takings. And what Kobach did was look at a lot of these early cases, many of them dealing with flood issues, with riparian issues, moving waters for mills and that kind of thing, where states required compensation under the compensation doctrine. He said that the theories behind those should certainly be extended to what we understand of regulatory takings today. And then he continues that the Blackman's assertion that until the end of the 19th century, state courts did not require compensation for government takings, short of outright possession, is simply incorrect. The requirement of compensation for non-acquisitive takings was commonplace in state constitutional interpretation of common law doctrines by the end of the 1860s. Another professor, Andrew Gold, also has stated similarly, due to scant and ambiguous historical record, the original intent of the Fifth Amendment of the Takings Clause cannot be, that the original, I'm saying, Takings Clause only cover direct physical invasions and is wrong. In fact, this direct physical takings thesis lacks historical support. Professor Eric Callies and Takings Regulations and Natural Rights talks about this as well, saying that the common law origins of how property was treated was part and parcel of the constitutional analysis, and property rights deserve protections from regulations from the Constitution. The last professor I'll mention is Professor Michael Rappaport. He was one that was cited by Justice Thomas, and he looked at regulatory takings and said, I'm a friend of regulatory takings, but I just cannot accept the idea that the original meaning of the Fifth Amendment covers the regulatory takings doctrine, as much as I would like it to do that. But he said, the 14th Amendment, the Privileges and Immunities Clause in the 14th Amendment may do that same thing. Now, of course, we know the Privileges and Immunities Clause is a better letter than substantive due process when it comes to economic rights. So maybe there will be a revival someday of Privileges and Immunities Clause. It hasn't happened yet. So where we are with the doctrine of regulatory takings and its historical basis is open to question. There are strong arguments on both sides of the issue. From my predilection. I agree with the ones that say that it is based in constitutional theory. But I understand the other ones, the arguments on the other side have merit as well. But when it comes to trying to see if the doctrine of regulatory takings has a future, despite its questionable past, I think Professor Eagle has helped a lot in establishing the future of the doctrine of regulatory takings, because he has provided us with a comprehensive guidebook that not only is nuts and bolts, but goes deeply into the theory and reasons why the doctrine of regulatory takings should be there in order to ensure that government does not go too far, in that classic term of art, too far in trying to accommodate public good and regulating for societal benefits. So Professor Eagle's work is, I think, when you have a treatise in regulatory takings this big, there's a lot there. And I think because there's a lot there, it's going to be much more difficult for the court to turn its back on its, as Professor Merrill said, its common law development of the doctrine of regulatory takings. The doctrine is here to stay. And I think we can thank Professor Eagle for some of its longevity now and in the future. Thank you.
I, for one, have found this first panel to be really exciting. It is a perfect example of the mission of this conference being advanced, actually working, and that is to advance understanding of property rights and to advance conversation about property rights. And so we're going to have some questions, but first I'm going to give Steve about 5 minutes.
Okay, well, thank you. I want to thank all the members of the panel for their very insightful comments. I'll start with Tom Merrill. I appreciated that he picked up on my emphasis on property as an important determinant before we get to takings and public use and so on, and also picking up on what I called commercial units of property, which is to say those aspects of property which are actually traded in the market and therefore get some objective significance beyond what the government or the owner might claim about it. In addition to the notions that Tom mentioned, the other important element of this is what Justice Holmes called reciprocity of advantage. If an owner has property and the owner is compensated in kind, that deals with many of what otherwise would be vexing regulatory property questions. If I own land on a street and I'm forced to set back my house by 50 feet, that's a cost to me. But if all of my neighbors up and down the street do likewise, all of the parcels are much more valuable, and so I am implicitly compensated in kind. And that survives Nick and any other kind of challenge, and that, I think, together with this notion of looking at viable notions of property, is what's important. Professor Leanne Fennell recently has done a series of articles also talking about what things people normally associate with each other in this bundle called property. With Professor Callies, I have to say, and maybe this is because I'm trained somewhat in public choice theory, which Jim Burling mentioned, I have really a lot of skepticism about public-private partnerships. George Lefko, who just retired as a professor at USC, who was my property teacher many, many years ago, talked about developers picking the best of the worst. We take property, we take land that government claims is distressed and can't be built on, and they want to get developers involved in doing something with it. Developers inevitably are going to pick the things that would be most susceptible to successful private development, even without large government subsidies. And when government becomes a partner, in addition to being a regulator, I think it kind of obscures the notion of regulation as opposed to proprietorship, to the mutual disadvantage for everyone. Also, in the Hawaii Park illustration, yes, there is investment value, there is speculative value. As a matter of fact, the more far-fetched and ridiculous a regulation might be, the greater the chance it will be overturned soon, and the greater the speculative value is. So bad regulations give rise to lots of speculative value. That's why Lucas talks about viable use as opposed to value, and I think that's a good point. Finally, as far as Jim Burling's comments goes, I have to say I really am very pleased that Jim, as a leading practitioner and mobilizer of a squad of leading practitioners, hit it right. I am basically part of what you might call the theory class. People who do theorizing, come up with notions of doctrines, and some of my brethren think that the more obscure that is, the better off we are. Keep us away from the hoi polloi, you know. But I think one of our jobs is to be useful, to help guide not only public discussion, but the work of litigators on all sides. And I'm gratified by the compliment Jim gave me that he thinks my work exemplifies that.
Thank you. So we've got time for a few questions, and I'm going to hand the mic to you so that everyone can hear. Anybody have, yes?
Thank you. New Hampshire just passed a law requiring owners on private roads that aren't maintained by the municipality, to contribute toward the maintenance of the road in the absence of a private agreement. And it took 3 years for them to pass it, and the rationale for it was that Fannie Mae would not buy loans where those properties are mortgaged on the secondary market, and thus it's not good for the home ownership market. So, but I just say that as backdrop. My question is, what are your thoughts on those types of statutes where private parties are being obligated to pay money, not to the government, but they're being required to contribute toward, well, in this particular case, the maintenance of a road?
Well, there's a very long tradition of special assessments in American law in which infrastructure developments, paving roads, putting in sidewalks, putting in sewers and so forth, were charged to adjacent property owners on the grounds that the value of their property would go up, and they were especially benefited by these infrastructure developments. They've kind of faded away. Not surprisingly, the adjacent owners usually fought bitterly against special assessments, and they became politically unpopular. But I think that tradition probably makes it hard to challenge these on constitutional grounds.
But when you do challenge them, if you were to challenge them, you have to, you know, the burden's going to be on you to proving that you're not going to benefit from that. That if the assessment benefits somebody else completely differently from your property and you're not benefited, then you got a basis for challenge. But if you get some benefit from that, it becomes more and more difficult to bring a challenge.
Any other questions? My younger assistant will handle this part.
Fleet of foot.
Professor Merrill, you, I think, said that under the Eagle theory, rent control would not be a taking. And I'm curious how you see it that way. It seems to me, and I think your rationale was that we don't go out into the market and buy and sell rent control. Right. But isn't that the taking of the ability to market your property at the actual market value?
Well, I guess my focus would be on whether the regulation itself sort of replicates some kind of exchange that takes place in the market. And lots of laws, of course, impair the use of property. States do things that push people into bankruptcy. I'm no fan of rent control, believe me. I think it's extremely poor public policy. But, you know, I don't think it fits the Eagle theory. I think you'd have to bring in some kind of substantive due process notion in order to challenge it. I would point out that the Supreme Court has never seen a rent control statute it didn't like, which is, again, maybe some rather small sample, but a bit of data that the regulatory takings case is not going to come to the rescue of landlords in New York and other states that are now being subjected to these ridiculous rent control statutes.
Yeah, if I may add one note to that, the original rent control statutes upheld by the Supreme Court pertain to very temporary wartime emergencies, and that one could justify, I think, under the police power. But when you get to a longer term, you have objective property interests, a leasehold interest, and a reversion to the owner of the fee. And in fact, we are transferring part of the reversion of the fee to the tenant because inevitably sitting tenants want the benefit of rent control beyond their existing lease, so we give them a right to renew. In New Jersey, and I think under the new New York City rent control ordinance, a tenant has to stay unless the landlord could show cause why the tenant has to be evicted, which goes quite beyond the notion of leasehold and reversion. So that's not justified by property law, and maybe due process is the answer there.
Yeah, let me just observe as well, as I think everybody in the room probably will recall from law school property, that although there are flaws in applying it because the Supreme Court did not necessarily reach all of the issues that it should have reached, you're going to still have to get over Yee versus Escondido. And there the court really wasn't very happy with the tax on rent control at all. You know, let's agree that the court should have decided some other issues, but hid behind the fact that it wasn't raised in a cert petition. That, of course, is absolutely ridiculous. The court decides what it wants to decide. If it doesn't want to decide it, it hides behind the cert petition. If it wants to decide it, it decides it has to go further. But until Yee gets thoroughly re-examined, it seems to me that that's going to be a problematical lawsuit to bring.
Yeah. Let me tell you about a rent control case that we had a decade or so ago. This was at a time before Lingle, when a takings test was something that failed to substantially advance a legitimate governmental interest. Now this would just be purely a due process challenge. And the reason for imposing rent control in California communities like Santa Monica was to help the poor, the less educated, minorities, basically those people that were socially and economically dispossessed. And we hired an economist to do a study comparing rent-controlled jurisdictions in California with neighboring non-rent controlled jurisdictions in California. In every case, as economic theory would predict, we found that the people living in the rent-controlled communities were richer, whiter, better educated, and socially and economically better off than those that are dispossessed. So we argued that the reasons given for rent control in Santa Monica to help these people were not being met, and they were being opposed. And we actually won at the Court of Appeal level in California, and rent control in Santa Monica was tossed out because it failed to substantially advance a legitimate governmental interest. However, we went to the California Supreme Court, and we couldn't help it. It was taken up there. And the California Supreme Court ruled that, well, yeah, none of those reasons are met, but there's another reason. Rent control keeps rents low. And that was an unstated reason. We came up with it, therefore it passes. So I think that just underlies the point that it's really, really difficult to get courts to overturn this. But you also ought to look at the case that was just filed in New York City. Richard Epstein was behind it, which is in large part another substantive due process challenge. And there's other things in there. I mean, the complaint's this long. But there is grounds for getting at it. And under Eagle's theory or under Merrill's theory, I think there are grounds for getting at it eventually.
Okay. Thank you so much for a wonderful discussion. Let's come back in 10 minutes.